Hi guys, welcome back. So this is the second part of the video. Before proceeding with the CRPC, let me say that in my previous video there was certain background noises. But I really cannot do anything about that because I'm making this video near my balcony where there are certain noises outside. So kindly can only ask you to focus on my voice and ignore others, and I'll try to minimize this problem as much as I can. And but I'm really sorry if that disturbance was creating an issue. uh, Also, it might happen that in this video also there might be some noises of outside world, but kindly cope up with that, and by tomorrow I'll come up with some solution to it. So now let's start with the uh, with CRPC. So in my last video I told you about that CRPC is divided into certain chapters and sections and schedules. Now uh, now what I am going to tell you is what is the scope of the CRPC. With the scope I mean uh, where all the CRPC is applied in this country. So the Bear Act says that the CRPC is implemented across India, excluding the state of Nagaland and some parts of the tribal areas. And also before the Jammu and Kashmir Reorganization Act was passed, this particular enactment at CRPC was also not applied in Jammu and Kashmir, but after the enactment of the said statute, now it is equally applied in Jammu and Kashmir also, but it's still in Nagaland and certain parts of the tribal area in the country. This particular statute is still not applied. However, the state government of those respective areas have the discretion to apply CRPC in that state and areas if they deem it perfect. So the other thing about CRPC, that CRPC is included in the third list of Schedule 7 to the Constitution of India. So the Schedule 7 of the Constitution of India talks about three lists. First is this union list, the second is state list, and third is the concurrent list. So the concurrent list, the subjects in the concurrent list are those subjects wherein the state and the center, the governments at the state and the central level, both can pass any enactment or make laws in the subjects given under those lists. So CRPC is one of those subjects that is mentioned in the third list of the Schedule 7. So since and also if you when you go through the Bear Act, you will see that various state amendments will also be given in the Bear Act, where many states have amended the sections that were originally there in the statute. So about so moving on, so today we'll be going through first chapter of CRPC. So first chapter covers from section 1 to section 5, but the most important thing in chapter 1 is section 2, which deals with the definitions mentioned in the CRPC. So there are plenty of definitions in CRPC given in section 2 from 2A to 2Y. But these definitions are really important from two point of views. First point of view is from the preparation point of view of the examinations, and the other point of view is from which they are relevant is pertaining to the practice that happens in court in daily in the daily routine. So there are certain definitions that are to be understood, and also there are certain definitions that are so easy in nature that when one you'll read it once and you'll get it. So I'll try to uh, restrict this lecture on those definitions only which are actually important and relevant to us, and are complex enough to be understood. So I'll just open my barrage. Yeah. So the first definition which is important for us is section 2a. So 2a talks about bailable offense, and section 2a talks about bailable offense and also non-bailable offense. So there is nothing much in this definition. It only says that whatever offenses are given in the list in schedule 1 as bailable offense, those offenses are bailable, and the other ones that are not mentioned under any list are non-bailable ones. So if you will, once you will go through schedule 1 of this statute, you will see that there are lists provided for you, wherein it is mentioned that which offenses are bailable, which are non-bailable, which are cognizable, which offenses are tried by which court, and other things, and also the imprisonment attracted to those offenses are also given. So from there you can get an idea as to which offenses are bailable and which are non-bailable. And the other definition which is important, uh, actually the first definition which is important is given under section 2c. It is cognizable offense, and also along with cognizable offense I'll deal with non-cognizable offense, the definition of it, which is given under section 2l. So coming to cognizable and non-cognizable, so cognizable offenses are those offenses, in the simple manner as it is also given in the Bare Act. It says that cognizable offenses are those where the police of the officer in charge has the power to arrest the accused without the orders of the magistrate, and non-cognizable offenses are the exact opposite of the cognizable offenses, wherein the police officer in charge does not have the power to arrest the accused without the orders of magistrate. So what is the purpose? So if something is enacted by the parliament, there has to be some purpose, some object as to why certain definitions are defined in a particular manner. And the same is the case with these two definitions. So cognizable offenses and non-cognizable offenses are bifurcated on the basis of the gravity of the offense involved. So for example, if you take cognizable offense, if you take an offense of, you say, section 302, that is murder, so per se it is a grave offense, and if if the parliament wouldn't have thought of making it as a cognizable offense, then the situation would be that the officer in charge would not have been able to arrest the accused without the orders of magistrate, and in such a case the accused could have fled, could have escaped from the spot or from the place of where the police could not have arrested him could have arrested him rather. And he could also have tampered with the investigation, and then when investigation would have been interfered with, and it basically would not have been very good for the case at length. So that is the purpose as to why cognizable offenses, which are actually grave in offense, there the officer in charge have been given the authority to arrest the accused without the orders of magistrate. And non-cognizable offenses are usually those offenses which are petty in nature or not of a very serious nature. So there also the police officer in charge has the authority to arrest, but the only qualification is he has to get a warrant from the magistrate or court to do so. So that, for example, if the offense is though not of a very grave nature, but the person accused is not cooperating with the police in the investigation, then in such a case the police officer can ask for the warrant from the magistrate to arrest him and to keep him in custody, and for particular time till for a particular time, so that the accused cooperates with the police officers in the investigation, and then he can be released after the purpose is fulfilled. Sorry. So this is the difference between cognizable and non-cognizable offense. So uh, a little piece of advice that I can give to the layman here is, uh, God forbid, if any if in any situation, if anything, or if any thing happens with you all, that if any if any of you or any relative of you or any known person of you gets involved in any such serious matter, and the police comes and asks him to submit himself to police and arrest, and police asks the police tells him that they are under arrest or anything like that. So what that person can do it is to check whether that particular offense that the police is asking, that the police for which the police has is arresting him, is whether that offense is a cognizable one or a non-cognizable one. So once he checks, if he checks it and the offense appears to be a non-cognizable offense, then he can himself inform the police that, see, the offense with which you are charging me, for which you are arresting me, is not a cognizable one, and you cannot arrest me without a warrant from a magistrate. You go to the magistrate, get a warrant, and I'll be happy to submit to you then. So this is so often the laymen do not have knowledge of these things, and they they are scared of police officers, and they comply with their directions without knowing their legal rights. So if in case anything happens to any of the to any of you or any relative of you, you can give them a little piece of advice which I just told you all, and in this manner you can save yourself from being arrested if it is not a fit case for you to be arrested. So moving forward, uh, how much time it is 12 minutes already for this video. So I think the third part of this, I'll cover the other portion in the third part of the video. Only 3 to 4 definitions are remaining, which are necessary to be covered in the next video, and then the first chapter will be over. So thank you guys, and I'll upload the third and the final video along with the other 2 videos only. And if in this video also there was some disturbance in the background, I really apologize for that. But again, I would ask and urge you all to only focus on and what I'm saying, and to please ignore the background noises, and I'll take care of it in my next video. And thank you.